welcome, Takano. This time is yours.
Oke, terima kasih Ibu Siti. Selamat pagi semuanya. Terima kasih banyak sekali lagi atas kesempatan untuk hadir di acara ini. Nama saya Sayaka Takano. Saya mengajar di bidang antropologi budaya dan antropologi hukum di Chuo University, namanya, di Tokyo. Antara tahun 2004 hingga 2006, saya sebagai seorang mahasiswa doktor melakukan penelitian lapangan di Medan. Dan dalam perjalanan itu, saya sangat bersyukur atas dukungan luar biasa yang saya terima dari Fakultas Hukum USU. Sekarang, mohon maafkan saya karena berbicara dalam bahasa Inggris. Okay, I will move on to today's topic. How is the concept of human rights internalized? I will put on my slides. Just a moment. Okay, here. Okay, let's. Okay. Oh, see. Okay. Let's. Sorry. Let me just adjust the monitor a bit this way. Just a moment. Okay. Okay. I will begin with a general overview of what I will discuss today. I will explain, just in case, what is cultural anthropology and its relationship to international law, since it may not be very obvious. After that, I will discuss the anthropology of human rights and its focus. There is much existing literature on the internalization of human rights, but as Sally Engel-Mary pointed out, in order for human rights ideas to be effective, they need to be translated into local terms and situated within local context of power and meaning. So this is where anthropology has its significance. And the keywords would be discourse and practice. I will talk more about this point later. I will then discuss the concepts of human rights from a legal anthropological perspective, touching on specific examples. The concept of human rights is based on the idea that it is the same everywhere in the world and everyone applied to everyone in the same way. But how is this universally generated? And I will then talk about what I mean by this, the theme, the concept of human rights being globally circulated and vernacularized. An important background to using the term human rights today is the fact that the term is circulating globally beyond national borders and translated and localized. In other words, vernacularized. And so many different people are using that term. From the perspective of cultural anthropology, we must pay attention to the fact that different people use the term in diverse ways and interpret it differently. I want to talk more about what this means, referring to that case in Fiji, the country of Fiji. Finally, to close, I will summarize what the anthropology of human rights has done and can do regarding the internalization of the human rights concept. So as some of you may know, cultural anthropology of human rights, an overview. As some of you may know, I think this, okay. Cultural anthropology involves long-term fieldwork in a variety of places and on a variety of themes. And it is a study that addresses the big question of what it means to be human through comparative studies. As a research method, we rather than surveys or statistical research, we use ethnography and emphasize qualitative research. And this field, by fieldwork, we usually conduct it for 1.5 or 2 years. Cultural anthropology is characterized by many subfields or subdisciplines called XX anthropology. There is, well, of course, some of you may have heard, there is anthropology of religion, economic anthropology, medical anthropology, and many more. While sharing the base of cultural anthropology, we are examining various topics. And my research has focused on the keyword law in particular. So the cultural anthropological study of law and society is my main research interest. This differs from jurisprudence or what is usually done in legal studies. Is because the word law first brings up images of written laws, court decisions, and vast accumulation of information about how to understand and apply them. But of course, none of these things function on their own. So in anthropology, we tend to put more emphasis on society. So our research has been based on the premise that the law functions in a complex relationship with the society that supports it, the society in which the law works, and the individual and the specific ways of people's life. So no law can function by itself, especially if it involves customary law. So it also deals with issues related to human rights, such as indigenous land ownership and how it is being dealt with in and out of court. And we also examine gender-related issues and various ethnic groups or sexual minorities, etc. So how do we look at human rights from legal anthropological perspective? There are a variety of cases in which human rights are at stake. It is important to examine and dig deep into each issues, but what can we see when we look at the cases globally and locally from a cross-sectional viewpoint, not only on individual cases and themes, but also across diverse case studies from around the world. In addition, we try to pay attention to the practice of human rights. So we will examine how people use the term human rights and what they do with it. There may be correct practices and deviations, not that maybe wrong practices. And it is said that we need to spread correct knowledge by raising awareness and educating people. But we take that another approach is also needed, that is expanding the scope a little more than just dismissing these practices as a mistake to taking seriously and focusing on how people use the term human rights. So how do we think about the concept of human rights in the first place? So what have anthropologists discussed about the concept of human rights? For example, Mark Goodall and Sally Engel-Mary are some of the people who have led the anthropology of human rights. One of their case studies include the development of social movements in Bolivia, South America. They focus on the fact that diverse groups and various people are mobilizing the concept of human rights. For example, they may be members of some community some committee of the United Nations, or people from non-NGOs working in the country, or local leaders whose livelihoods are based in the villages. Each of these people understands the concept of human rights differently and uses it differently. This is often not consistent with the understanding in the field of international law. But Goodell says that it is important not to dismiss some things that are not quite considered correct from the standpoint of international law. About this point, Goodell uses the term open source. Human rights is open source because the concept of human rights is not limited to what is written in international treaties and the like, but is inseparable from each practice. And he says that there is no it is not like there is some ideal concept, some right concept, and people misunderstanding it. Because the concept of human rights is something that everyone can use and rewrite. So if we don't look at that specific practice, even though it looks like a misunderstanding at first sight, we cannot understand the human rights concept as a whole. So that is why the discourse for the approach focusing on discourse or practice is significant. I will explain more about this looking at discourse and practice of human rights theme in a moment. Let me try to make it a little bit more clear by comparing it with other approaches. First, it is conceptual approach. Conceptual approach is to say that human rights are the common property of humankind. Human rights are rights we have simply by being human. They are equal. You either have them or you don't. It is not a matter of degree, and they cannot be taken away. The reason for this is that we cannot cease to be human. So even, for example, criminals have human rights, of course, so they exist universally, regardless of the right or wrong of some person's act, as long as they're the same human being. So it's like philosophical, to think the word conceptual or philosophical approach. Another approach to think about human rights would be legal. This might be the most familiar one, most easy to understand. As for this legal approach, human rights is the set of international laws and related instruments established in response to the Universal Declaration of Human Rights. The Universal Declaration of Human Rights was enacted in 1948. and there are a whole set of conventions. Still, it is terribly new to think about the history of human being. There are also, for example, to give you some example, there are also international criminal codes established in 2003. So from a legal approach, human rights are a series of international laws and related institutions that were established and are to be viewed in accordance with them. So only those that have been officially recognized and codified would be worth discussing or become subject of study. But there are more stuff to look at from the anthropological perspective. So neither of the above two is approaching from discourse and practice. Again, we analyze what is done and how human rights are talked about within the framework of human rights, rather than viewing human rights practice as a site of conflict between universal human rights and rights concepts and reality. We see both as important parts of the human rights concept. This is anthropological approach to human rights look like in a very short expression. So apparently, the term human rights face some difficulties in the process of internalization, and it's not an easy task to be done. So we should rather consider seriously why and what is happening. For human rights to function, as I said before, it must be properly situated in a local context of power and meaning and accepted by society. As I said earlier, what is at stake here is that human beings are supposed to be treated the same way everywhere in the world in terms of human rights. In other words, the conceptual approach is oriented toward the value that as long as we are human beings, we must be guaranteed no matter where we live or our circumstances. However, it inevitably conflicts with each individual's circumstances because it is the same everywhere in the world. We are there are various situations that we face. So do we need to take into account the circumstances with each situation? Like, for example, when people say this is the way it is in Indonesia or in Japan, or terms such as tradition or culture could always come up. And another point is the expression. In other words, when we say that everyone should respect human rights, there's not clear objection to it. But if so, if we discuss into detail, various viewpoints can collide. But what is lost when we do this is the problematic or attention-getting aspect of changing the status quo. The sharpness of the reminder that something so unreasonable exists could be lost if we look for an acceptable expression or acceptable explanation of human rights. So the concept of human rights is fraught with such difficulties to begin with. So these difficulties are inherent in the concept of human rights. It has only been just 70 years since the Universal Declaration of Human Rights. Therefore, people tend to bring ideal cases from overseas and talk about how things are different in their country, or how it is good that their country do not have this and this situation while other countries do. But this is not the case. Human rights face difficulties throughout the world. So what kind of reactions that the concepts of human rights provoke in various parts of the world? How have they been accepted or not accepted? Or what is happening in the, but everyone is trying to um, to in, to understand and internalize the concept of human rights. So what is happening in that process? So it is an analysis of the practice of human rights that considers what the process of acceptance of the concept of human rights can be. So I will divide these processes in some two perspectives. And first is how universality of human rights concept is generated. I would like to talk first about the indicators. Since the 2000s, the influence of index has expanded in a variety of areas. As you may already know, universities are being ranked, and there are also indexes on happiness, press freedom, good governance, corruption, gender equality, and so on. So many indicators, numbers to understand the situation. In the field of human rights indicators by the Office of United Nations High Commissioner for Human Rights exist, and it is very powerful. But how are these indicators created? When we look at indicators, we look at the numbers, but not really on the process of its creation. Well, you might know, you might some idea if you are into statistics, but the basic process is that you have primary statistic, such as population by sex, age, etc. What could be these numbers? What could be counted? And from them, they generate secondary statistics like maternal mortality rate, the domestic violence incidence per woman in relationships longer than 12 months, etc. So these are numerical values and their relationship to each other. And they put all these numbers together in many aspects, and they create a ranking by country. So what is being excluded in the process of creating these indicators? What is getting lost? So these indicators, of course, rely on existing statistical data. If there's no data, you can't generate these indicators. And there are difficulties in quantification. By this, I mean that if the numbers, when you talk about numbers, you think about whether it is high or it is low. But if you talk about domestic violence, sometimes it's not just numbers. It is problematic that it just exists. It's not like the ratio is low and you just don't have to look at it. So quantification faces some difficulty. And there are also political influences, and these discussions are more more detailed. You can, if you want to know about the details, it's in those referring the books I made the list of at the end of presentation, and I can share it with you. So if you are interested, I hope you can access these literature. And there are also so there are also political influences, and some people, some countries may not respond if if there's data, if even though there's some statistics, it might not be provided for the indicator. I think you can easily imagine that happening, and there's political influences. And what appears to be objective, seeing that, so according to the indicators, these countries have more problems and these countries are more in good shape, but it might be created through specific practices. And some are designed to serve a specific purpose, for example, to get funding, etc. So the objectivity of these indicators should be always closely examined. You shouldn't take the objectivity for granted. And another point that anthropologists have raised is the making process of international treaties. This book, The Network Inside Out by Annelies Riles, is a study on how and by whom the meetings, whom the UN committee review the text of international treaties, and how knowledge about human rights is produced, and what is considered important and what is not considered important in these meetings. And again, these things are not could not be taken for granted. And the next point is the global circulation and vernacularization. And here, there's a case study from Fiji by another anthropologist. She looks at the conflict between global law and local justice, the inevitable tension between the universal and the particular. The subject of study is CEDAW and its activities in Fiji. There was a hearing in Fiji by the UN Committee on the Elimination of Discrimination Against Women, CEDAW for short, and the first report was submitted to CEDAW by the government of Fiji in 2002. And in this report, certain types of village mediation called bulu-bulu have become an issue. So bulu-bulu means to bury, and it refers to the practice of a perpetrator giving a gift, such as a whale's tooth, to a victim to apologize and ask for forgiveness. And the victim receives the whale's tooth and settle some conflicts and disputes. And there is a ritual value to this whale's teeth, which is shown in this photograph. And CEDAW demanded government regulation of bulu-bulu. They said that this practice, bulu-bulu, violates women's rights by marginalizing women victims of rape, by allowing male relatives to handle cases, and by preventing perpetrators from receiving proper punishment. And there was a strong reaction from the Fijian side. There was a response. Fijian society cannot sustain with itself without bulu-bulu. Fiji's side raised the issue of some misuse brought about by urbanization and modernization. So the tradition was changing and there were some side effects to it, in other words, but it's not bulu-bulu themselves was the problem. However, the hearing ended without any coordination of views with the commission. And there was the obvious lack of time to this process because the 23 experts had to respond to 8 countries in just 2 weeks. So, although I could not go into the details of the case study here, there is ambivalent interpretation of being local or traditional. So there are what local or rooted in tradition can easily be interpreted in both senses. So there are cases where it is spoken of negatively, or there are cases spoken very positively, and there's a very thin line between it. Okay. So there are cases that are spoken of as negative. There's a chat. Oh, okay, attendance list. Okay. Cases that are spoken as negative. A typical example of this would be the issue of FGM, female genital mutilation in Africa, which has been the subject of worldwide criticism as a pre-modern practice that should be improved by spreading correct knowledge. On the other hand, there are cases in which tradition it's spoken of in a positive light. I have written before about local conflict resolution methods as a kind of restorative method of conflict resolution. But to explain it more carefully, it is often said that reaching an agreement through discussions involving people who know the parties involved is effective in healing the victim's wounds and reintegrating the perpetrator into society. But criminal justice cannot provide that. While it may be a fair and impartial process, it has a different meaning and objective to it. So talking to it with the people around you is better, but it could also lead to an accusation received by the bulu, like just where is the justice? It might not be the ordinary social norms might not mean justice. So cases spoken positively would include local dispute resolution methods that restore justice, and there's a discussion around use of customary law as a legal resource. One of these examples would include Ho'oponopono in Hawaii. So it's kind of a ritual of forgiveness, and is partially getting included in the criminal procedure, like especially those involving family members and children. So when there is a practice that appears to be traditional in some way, it could be explained as bad practices to be eliminated, or conversely, traditions to be respected, depending on the situation or at the time, who is talking about it, and so on. So it seems to be quite arbitrarily assigned to one side or the other. So what is going on here is sort of an oversimplification of the culture and traditions of others. We are talking about human rights, but this also includes culture and tradition from an anthropological perspective, because they are often discussed as opposing polars in society. We see, and when we do that, we see culture and tradition as something that has always remained the same. And we think that there is something very solid in the form, like the Fijian bulu bulu. But is that really so? To give another example, let us think about domestic violence in in a particular country. We may see it as a problem that is happening in like Japanese or Indonesian society, but we may not see it as representative of the nation. I mean, you don't say all Japanese people do that. That's why Japan is the way it is. We see it as a problematic behavior of some people and what to do about those people. But when you hear about, I'm not sure if which impression you got, but when you hear about buru buru in Fiji, for example, we might instantly jump to a conclusion to say that all the buru buru practices must be stopped now. This is an oversimplification of the culture or tradition of some other society. And the problem is that we think of culture or tradition as overly static, overly rigid and uniform with regard to the culture and traditions of people who are not us. So it is important to understand more complex background situations. So tradition and cultures is diverse, could be diverse and very fluid. So if we do not always stop and think about who is speaking and what they are using it, rather than jumping to the obvious, some quick conclusion, these conflicts will not benefit anyone. So we have to look at who uses them, under what circumstances, and for what purpose. So cases that I have talked about as I mentioned in Fiji, I think it could happen everywhere. And so I don't think the Fijian case is that special. So I want to conclude by commenting on what the anthropology of human rights has revealed. Oh, sorry, not yet. Okay. Okay, so how is the concept of human rights internalized? I wrote beyond the dichotomy of human rights versus tradition and culture. So the difficulties surrounding the internalization of the concept of human rights are often understood as a conflict between human rights as a universal value and tradition, culture, or national identity or characteristics. Indeed, the assumption of a global idea of human rights to be the same everywhere, and the complexity of local practices such as local practices, for example, the complexity of each situation inevitably entail a conflict. However, in light of the practices surrounding human rights, as discussed today, I would like to emphasize again that both sides of the issue are not solid, one-sided human rights. What human rights are supposed to be and what they are talked about are also very fluid and in the process of being created. And conversely, what it's spoken of as traditional culture also could change dramatically, could be changing dramatically, depending on who it's speaking, when, and in what way. So we can think about human rights through various examples of how they continue to be created through practice. And finally, I would like to say again that this does not mean that the concept of human rights is hopeless. There's constantly changing and created by someone else, but they're of course not meaningless. And we as individuals also participate in that process. So while acknowledging the possibility of coping with difficulties and change, we must pay attention to the existing diverse processes while also looking at what is happening so that discourses and practices, the way people talk about human rights and what they do, rather than giving up the process altogether. So in addition to the Fijian case mentioned before, and I would love to hear about the cases cases that pop in your mind, the cases that you are interested in now. So it is necessary to ask what are the backgrounds of these interpretation and discourses, and where and how are their effects manifested to think about internalization. And these are some of the literature's important books on anthropology of human rights if you are interested. Well, yeah, I think we have 10 more minutes, but I think I would like to use the time for questions, your questions or discussions. Thank you.
Yeah, thank you, Sayaka, for your slide and then the meaningful, insightful explanation about human rights when we see from legal anthropological. And then if you guys, a student, can you hear my voice?
Yes,
You
ma'am.
student?
Yes, ma'am.
Yeah. There are many questions maybe?
I have, ma'am.
Yes, this time is yours, please.
Okay, my name is Sandrina Rahmaputri. My question is, how are human rights norms internalized differently across different sectors of social life, like example, family, religion, economy, or governance within a given society? What accounts for these variations? That's it from me. Thank you.
Thank you, Sandrina. I'm not sure if I got it. I got your question right. So you are asking how the concept is internalized in different sectors, you said.
Yes.
So I think it is. I think the interesting about the concept is that it's interpreted and translated in diverse ways. So it's not a uniform process. it's not the same everywhere. So the words might be the same. The word they use might be the same, like they use the word human rights or hak asasi manusia, but the interpretation might be very diverse. So what is happening is also diverse. So it's not like it's accepted in the same way. So and it shouldn't be. I'm not sure if we should even aim for the uniform acceptance or uniform discussion. That may be because I'm an anthropologist, but I'm more interested in looking at how people talk about human rights, in how people from different sectors talk about human rights. So is there any, there's a question for me, but is there any specific case you would like to touch on around human rights? What the one you are interested in, or how, what kind of sectors involved?
I think no. I'm just trying to asking about human rights across different sectors. That's it.
Okay, thank you so much.
Thank you,
I'm not
ma'am.
sure if
Okay, thank you, Sandrina. Anyone else? Sebelumnya, maaf, mahasiswa paham yang disampaikan Profesor Sayaka tidak?
Oh,
Bagaimana mahasiswa? Jadi tadi ya, kalau misalnya Sayaka,
yes.
ya, saya mau mencoba memantik mahasiswa terlebih dahulu. Apakah memang mereka benar-benar paham tentang apa yang kita sedang bicarakan?
Oke.
Ya.
Tidak masalah.
Oke. Jadi ya para mahasiswa, kita berbicara sebenarnya tentang hak asasi manusia yang dipandang melalui sudut pandang antropologi, sebagaimana keilmuan dari Profesor Sayaka Takano. Konsep HAM yang dipandang melalui antropologi dan legal antropologi itu berbeda. Ya, berbeda. Ada pendekatan konseptual, ada pendekatan praktik. Tidak bisa pemaknaan ataupun penerimaan tentang konsep hak asasi manusia itu bisa saja berbeda di berbagai tempat, subjek, bahkan lintas negara gitu ya, dari sudut pandang budaya, bisa yang seperti dicontohkan oleh Sayaka tadi, ada yang ada di Fiji, kemudian ada yang dicontohkan tentang karakteristik budaya yang mungkin bisa dianggap itu sebagai kekerasan, tapi itu karakteristik budaya. Nah, disebabkan karena memang budaya itu merupakan satu hak dasar yang kita miliki sebagai manusia, maka budaya, tradisi itu juga dianggap sebagai hak asasi manusia, indigenous people, yang dimiliki oleh masyarakat adat ataupun masyarakat lokal. Nah, tentu ini harus kita maknai dengan bijak atau kita sikapi dengan bijak. Nah, lalu bagaimana agar kita bisa melihat bahwasanya apa yang menjadi hak asasi manusia itu bisa kita terima secara luas, ya, secara umum, jika kita bisa menerapkan yang pertama, kita mengetahui mereka siapa, keberadaan mereka di mana, kemudian memandang sesuatu tradisi ataupun budaya itu tidak berlebihan. Nah, jadi untuk hal-hal yang memang sifatnya sensitif, bagi kita itu suatu hal yang mungkin adalah kekerasan atau hal yang dilarang misalnya di negara kita, nyatanya itu sebagai hak asasi manusia. Jadi pemaknaan ataupun pandangan kita terhadap hak asasi manusia agar hukum hak asasi manusia itu bisa terinternalisasi ya. Terinternalisasi itu kita bisa memaknainya secara mendalam dan kita bisa mengkonsepkan itu sebagai bukan struktur hukum, substansi hukum. Agar kita bisa memaknai hak asasi manusia itu sebagai substansi hukum, maka perlu beberapa pendekatan. Contohnya tadi yang disampaikan oleh Profesor Sayaka Takano, kita berbicara pendekatan antropologi dengan konsep hak asasi manusia. Kira-kira begitu apa yang kita bicarakan. Bagaimana, semuanya sudah paham? Ada yang mau bertanya dengan bahasa Indonesia biar saya coba menghubungkan, atau kalau Profesor saya katakan bisa langsung memahami, alhamdulillah. Bagaimana? Mahasiswa ada yang ingin bertanya?
Saya, Bu.
Silakan.
Saya coba langsung bahasa Inggris saja ya, Bu.
Okay, good.
Sorry, first, the lecture, Miss Takano, Madam Takano, say that argues about the both of the human rights and the cultural tradition are fluid and constantly being created through practice. Maybe you can elaborate at this point and why it's significant to recalling it universally as human right with local context. You got it, man?
Yes, I did say that both human rights and traditional culture is being constantly created through practice. And then, so your question is, can you say it once again?
Oh, it's more like, can you more make it explain more? You can elaborate at this point and why it's significant.
Why it's significant?
Yeah, at the universe of local context.
Universal and local context.
Yeah.
Okay. Well, thank you very much. Okay. Why it is important is that when you think of the concept of human rights as a solid and concrete entity, it leads into attitudes such as there are some people in the world who does not really understand the concept very well, so they're bad. Like ada orang yang bodoh tidak memahami konsep hak asasi manusia, jadi harus mengajar gitu. But it's not that simple, because people can only if that attitude is not at all unnecessary. We should learn about the concept, but we should when we have in mind that human rights concept is open source, like this scholar Goodall had said. It's not like there are orang yang bodoh and orang yang pintar gitu. We are all participating in the process of accepting and interpreting the concept. So that's that, like, you just don't look down into people who are not really much understanding, because they have their backgrounds and their reasons for doing it. Is that am I Am I delivering the message? So you have to understand why they are doing it that way. So you can be more open-minded, and that would lead to more fruitful discussion. So that's about the concept of human rights. So understanding its fluidity leads to more fruitful discussion. And the tradition and culture, I think it's more easier to understand, maybe. I'm not really, I would like to hear what you first think about when you said that Indonesian tradition or Indonesian culture. When you think about that word, what they mean by that word could be very different. So it's some people, there are discussions that really tend to take the culture and tradition as a very solid entity, but it's those discussions tend to go around in circles, because the content of tradition and culture is what the speaker thinks as tradition and culture. So it could be very biased if we don't take into consideration the fluidity and the constructing process of the concept. So it goes hand in hand, because in discussions about human rights, these concepts really often appear, like the Indonesian society could not accept this because it contradicts with culture or traditions, but it's not that true because they are both fluid and changing. So that makes us possible to look at the discussions from a different perspective. So that what I meant by the significance of that approach. Is that any? Was that something? Did it help? Like.
Oke. Gimana,
Thank
Juan,
you.
Philip?
Maybe, ma'am, can you pinpoint some main point of the
Ya,
answer
gini.
so can resume it?
Ya. Saya bahasa Indonesiakan saja atau bagaimana? Juan?
Bahasa
Oh.
bahasa Indonesia saja, Bu.
Maksudnya apa gitu, Bu? Kayak
poinnya gini.
dia saya ambil main point gitu, Bu.
Ya, nah jadi yang dibilang tadi sama Profesor Sayaka Takano, kita tidak bisa memaknai secara memaknai secara keras, strict atau absolut atau yang, jadi kita harus memahami, kita jangan dulu memahami konsepnya, tapi kita harus memahami dulu awal mulanya ada satu tradisi misalnya yang dianggap itu sebagai itu hak asasi kah atau itu tidak hak asasi kah. Nah, kita harus lihat dulu latar belakangnya, alasannya. Kita harus memahami dulu mengapa itu bisa ada dan dilakukan sebagai satu tradisi. Nah, sehingga itulah yang kemudian secara bijak lantas kita bisa memahami pelan-pelan tujuannya apa dan manfaatnya buat mereka apa. Nah, maksudnya elaborasi antara HAM dan tradisi ini tadi memang kadangkala tidak bisa kita memiliki nilai definisi ataupun nilai makna yang sama. Jadi kita harus benar-benar melihat, karena antropologi itu memang ilmu yang mempelajari perilaku, tingkah laku manusia, maka kita harus juga memahami mengapa mereka berperilaku seperti itu, tujuan mereka berperilaku seperti itu dilakukan terus-menerus. Nah, sehingga kalau misalnya tradisi itu sudah menjadi satu kebiasaan dan dilakukan terus-menerus di wilayah tertentu itu, ya bisa saja itu kita katakan sebagai hak asasi manusia. Jadi elaborasinya kita harus memandang dari latar belakangnya mengapa ada. Makanya kalau kita meneliti itu yang cenderung kita bawa itu adalah pertanyaan 5W1H itu, mengapa, apa, bagaimana, siapa. Begitu kira-kira Juan.
Terima kasih, Bu.
Baik, mungkin ada yang lain? Anyone else? Okay, maybe I want to ask you, or maybe I just wanna know your insight about the condition in Indonesia, especially in Sumatra, and we know that Indonesia has many culture, many language, ethnic, yeah. In Sumatra, especially in Sumatra, we have Aceh, we have Aceh, we have Minang, we have Batak, and then Batak. Let's say we have many ethnics in Batak, Mandailing, and then Karo, and then the Pak. So many cultures, so many I think tradition, yeah. In Minang, Sumatera Barat province, if you know that, in Minang has has tradition in how we say perkawinan. If I as a woman, if I want to marry with a man, and then I should saya yang harus melamarnya, yang harus melamar pria itu.
Melamar itu artinya apa, Bu?
Melamar itu how to say
Propose.
Oh, propose. Okay, thank you.
To propose the man. Propose the man. Okay. And the other ethnic, this tradition is not usual. So if we understand about the I think tradition in Minang, any I think adagium or yes idiom or adagium said that adat bersandikan syara. We have adagium, adat bersandikan syara, syara bersandikan kitabullah. Let's say this adagium, the definition is the culture, the tradition, has to look the religion, and the religion has to look the how to say maybe kitab Tuhan, ya kitab
Tuhan,
kitab Tuhan. And in Islam, to propose a woman should be do with a man. This is contradictive, yes? Contradictive condition. So I think I just want to know your opinion about our culture in here.
That's really precisely the reason Indonesia is such an interesting field of study for legal anthropologists. So that's why I chose Indonesia as my fieldwork site. And Minang is a very famous example, not just the proposing, but the matrimony contradiction between the matrimonial society and Islam. So there has been many scholars writing on the contradiction between the Islam and about the potential contradiction maybe. So and it's a very interesting point, and it really depends on the individuals. So we can ask about what the individual, each person think. So it might depend on the partner too, if partner understands that or understands where she come from. It could be all about communication, and maybe she has a very modern mind, want to free herself from the the culture, and maybe it maybe well, she doesn't have to care about what should. So maybe she can do what she wants. She wants to do what she wants, or maybe she will ask the partner to propose for her. So it really depends on the choice, and the anthropologists are really interested in the each cases and in each individual's logical thinking, to how does each person make sense. I think it could be various cases, various decisions they make, and depending on the life course. Maybe if the person has an experience studying abroad, it might affect her way of thinking. And if she has lived in West Sumatra for all her life, that would consist her background too. So it's a possible contradiction, but it's up to the individuals to make the choice, I think. And there would be social pressure, so it's not completely, maybe she might be forced to choose a certain way of behavior or a certain practice. So I really admit that there is a potential contradiction, and I also imagine that there may be diverse ways of responding to it, and it should be changing over time. So I'm interested in the variations and the change and continuity of it as an anthropologist. So so my questions for you would be, how strong is the rule, the social norm, for these Minang women in contemporary Indonesia? How strong could they be? Is it really something? If she goes against that rule, what will happen? She will be
Okay. Maybe we talk about the sanction, yeah. In Minang, let's say if a girl or if a woman propose to a man, it's just not be strict tradition again. Maksudnya tidak lagi menjadi satu tradisi yang mutlak.
Okay.
I think it's depends of the family maybe. Jadi tergantung pada kesepakatan keluarganya, and then ability of the man or woman. Yang saya lihat perkembangannya itu sudah lebih kepada kesepakatan. Boleh perempuan, boleh lelaki. Karena Ya, religion tidak melarang, ya. Kemudian
Iya.
ada juga masih membuka itu, sebab apa? Ada adagium tadi. Adat bersandingkan syara bersandingkan kitabullah. Let's say we can say the adagium is the principle of the Minang. So if they maybe in one contradictory condition, this principle has exist. So
Principle exists.
yeah, principle exists. So there is no problem about the contradiction. Is depends of the kesepakatan si pihak perempuan ataupun pihak si lelakinya begitu. Kalau sanksi lebih kepada, kalau banyak misalnya sanksi-sanksi adat itu lebih terlihat di Aceh.
Oke.
Iya, di Aceh itu karena memang mereka memiliki konsep syariah konsep in the government, and then kehidupan sehari-hari. Jadi mereka menyesuaikan, menginternalisasikan prinsip hukum Islam ke dalam sistem pemerintahan. Seperti ada misalnya terdapat perempuan dan suami yang tidak sah sedang berdua-duaan, ya, let's say pacaran, dan itu ketahuan, itu bisa dihukum rajam, cambuk. Ya, seperti itu.
Iya, jadi tergantung pada daerah itu.
Tergantung dari daerah.
Tapi kalau dilihat dari luar negeri, bisa dikritik.
Kritik.
Kritik
Ya.
itu juga. Iya, benar.
Oke.
Ya, mengerti. Iya, terima kasih, Bu.
Terima kasih, Profesor Sayaka. Ada lagi kah mahasiswa? Bisa bahasa Indonesia kok, Profesor Sayakanya.
Izin Bu, boleh tanya nggak Bu?
Oh, boleh Liza, silahkan. This
Si-
time is yours. Mahasiswa S2.
Izin ya Bu.
Iya.
Thank you, ma'am.
Halo.
The first of all, please let me introduce myself. My name is Liza. I am a master student in Universitas Sumatera Utara. So previously we talked about legal anthropology approach, which means I can conclude that it interconnection between human, legal, and culture, if I'm not. So and based on this based on the statement that previously Ibu Siti Nurrahmi said about the culture in Indonesia, so I just popped up in my mind about the culture and tradition in Africa, in Togo. If you ever heard about kakia, kakia refers to genital mutilations, female genital mutilation.
FGM.
Yeah, in Togo, one of the region in Africa, it is illegal. If a woman marry a man, yeah, they need to do this tradition, female genital mutilation, as circumcision in this Indonesia. We familiar with that. So, and I had read in the book Fauzia Kasinja. The title, the book is "Do They Hear You When You Cry?" Fauzia is one of the victim in this tradition. Fauzia, at the age of 17, she forced to marry a man who already had 3 wives, and she need to prepare for the ritual of female circumcision. And because she thinks that it's a human rights violation, so she decided to escaped and fled to United States to seek asylum. So the United States, she is as asylum seeker. And at the end of the process, she get citizenship, United States citizenship, and finally grant asylum on 1996. And I go to the conclusion that United States admit that this tradition as a human right violation because they accepted the asylum as Fauzia as on the ground of gender-based persecution. So I just realized that there is a country that accepted the tradition as a human rights violation, and I just think maybe there is another country that accepted as the same on the United States. On the other hand, in Africa, it is a tradition and legal. So I want to raise a questions about your opinion about this tradition because in Africa it is illegal and in the United States they say that it's a human rights violation. And I think that there is a lot of tradition in the world that maybe it is a human rights violation, but just not a pop up our uh in our like daily life because it's not in the media. I just want to raise a question about that because I uh I read about Fauzia in a novel I bought in Penang, Malaysia, and I just think genital mutilation because genital mutilation is known in one of the religion in Indonesia, of course. Thank you, ma'am. Thank you for the opportunity, moderator. Thank you.
Yeah, thank you for the question. That's a very hot discussion around. There's a very hot topic, and so it is closely related to what I have discussed today. And so what I would like to emphasize is that the talk about FGM is very easily put into the framework of human rights versus tradition. So the one actor or typically United States would say it's a human rights violation, and the other sector would say that it's our tradition and you can't mess with us doing it. So it's and as long as this framework continues, it would be so each side would not listen to the other side's argument, and things would take a very much longer time to change. Each of the groups would be very get stubborn and repeat saying the same things over and over again, and it's not fruitful in my opinion. And each sector would accuse the other of not understanding and being not very clever maybe. So it would be like putting each other down. So I think it's a very problematic situation. So as an anthropologist, I would like to take a distance from the judgment or the question that FGM is a human violation or not, because FGM is what is included in the practice and discourse surrounding FGM could be diverse, and part of it would be I'm not just simply protecting the tradition unconditionally. I'm all for change if necessary changes should be made, and people would be, if there are people wanting to change, I think they should be heard. They should be they shouldn't get their voices eliminated. But I think so we should really look more closely into the discourse and practice surrounding the FGM and the debate, because why do people continue that practice? What's the meaning? And if that could that meaning be be pursued through, for example, other practice? Is it something that only FGM, well, some people would say that only FGM would do that, serve that purpose, but is there any possibility that for changing it through adjusting the practice, maybe? And is FGM so, or is the practice so uniform? Is there any variation in it? Is there any space for change? And I would like to pay respect to the people involved before dismissing them as being pre-modern. I think that would be my response by now.
Yeah, exactly. Unfortunately, we can judge, as you said, judge there is a human rights violations, but I assume that maybe one day, if there is a lot of research to prove that it's not a good thing, and how it can be stopped. It will be stopped one day, I hope.
Yeah.
I hope there is a lot of research to prove that it's not a good thing. Until today, there is research, but maybe not a lot of them talk about FGM, and it still continue. Okay, thank you, Takano, ma'am.
Yeah, thank you, Lisa.
So we need research to prove that FGM is a cruel thing. Yeah. Okay. I think maybe anyone else, if you have no question more, I have to maybe Sayaka Takano have no more time with us. Yeah. Anyone else? Enough?
Nothing.
Enough? Okay. Thank you once more, Sayaka. Ohayo gozaimasu. Arigato gozaimasu.
Yeah. Terima kasih
Professor
banyak. Arigatou gozaimashita.
Yeah.
Okay, thank you.
Okay. I think this time will be finished. And then we hope that all participants enjoy with our discussion as much as we did. Maybe before I close this session, I would like to documentation our participant to have some photo shoot. Yeah. Sebentar. Okay. 1, 2, 3, smile. Okay. This is this is the end of this session. We will meet again, maybe Sayaka in Medan. Yeah. At another session. So happy to have you today. Have a good day. Konnichiwa.
Ya, terima kasih ya. Selamat siang
Thank you.
semuanya.
Assalamualaikum
Oke.
warahmatullahi
Oke,
wabarakatuh.
sampai jumpa.
Sampai jumpa kembali.
Mm-mm.